What do you think you will do that will make sure those judges are sworn?
It is of utmost urgency that these 40 judges are sworn in office. So I will negotiate because, like I said, I have very good negotiation skills. If there are problems with some, that problem can also be sorted out, because if you have a problem as a judge, it must be sorted out one way or the other.
So that is the Chief Justice, Martha Koome, as she appeared before the vetting panel of Parliament, that is Justice and Legal Affairs Committee. I believe it was on 13th of May 2021, and barely 2 weeks after her appointment, then you see the appointment of the 34 new judges. In her statement, she says that she had no role, but she had already promised that she has very good negotiation skills, that should ensure that the judges are appointed. If there are issues with some, then they must be sorted out in one way or the other. And Advocate Ogolla, when you look at all those things, of course she said that she has no role in it, and we have to take her word, but how is the public supposed to perceive what she prepared us for and what has happened just barely 2 weeks into office, and what is her role now to ensure that this standoff is dealt with?
I think it's first of all, there is nothing illegal or irregular with the swearing in of the 34 judges, because they were interviewed based on their application, and they were recommended for appointment based on their demonstrable competence. The president ought to have appointed them a long time ago. If he has appointed them now and they have been sworn in, that is perfectly procedural. But there is everything wrong with the failure to appoint the 6 judges, because the failure to appoint the 6 judges does not advance the rule of law and does not show respect for court orders. Because I represented the Law Society in that case, the Adrian Kamodo case, petition number 396 of 2019, and the High Court, Justice Lydia Chode, Justice James Makau, and Justice Chacha Mwita, they said unequivocally that the president has no role to play in deciding who becomes judge and who doesn't. His role is merely facilitative. And the court went a step further and said the timeline for complying with the constitutional directive is 14 days, if it is not expressly stated. So from the time these nominations were given up to now, I think there's been a lot of time. So when you are looking at these appointments, the idea is not to criticize the swearing in of the 34 judges. The idea is to question why some judges were left out. But I must add that the president has scored a serious political and moral dividend when the 34 judges turned up for swearing in. Because we already said there was a moral burden. There was no legal hurdle that could preclude these judges from presenting themselves from being sworn in. But there was a moral burden. Justice Mumbi Ngugi, for instance, is a darling of Kenyans. She's loved, she's fierce, she's independent, she's eloquent, she's very intelligent, very fiercely loyal to the Constitution. I think she may have failed the test of moral competence, in the sense that Mumbi Ngugi has sat with G.V. Odunga in many benches. And although nothing stopped her from and other judges from presenting themselves to be sworn in legally, because they applied individually. But at a point of moral reflection, I think, I want to believe that you must have reflected on it carefully. As Jan said, I'm going to be sworn in, and I know that some of my colleagues have not been appointed. What is your reaction to that?
Did she even have the time? Because the appointment was
yes,
Thursday
even
night, the swearing in is
how much time
Friday
do you need?
afternoon.
You just need in the spur of the moment. Think on your feet. What is right? What is right and wrong does not require reflection. What is right and wrong is right there, right before your eyes. The thing is this, they have now validated the decision to make the part appointment. And the president now is much stronger on the political and moral front, because there are dividends that he has accrued from that. But on the law.
But Wakili, what would happen if you've been appointed to a state office and you refuse to turn up for appointment, for swearing in? What would happen?
Nothing, in law, nothing would happen, because what would mean that would require interpretation. They would say, listen, there are many reasons why a judge may not turn up for swearing in. It could be unwell, he could have traveled, they could be having personal circumstances that make it impossible. to turn up for the swearing, then they'll be sworn in at a particular time. The court would have to interrogate later.
Let me put it this way. If a president has been elected, president-elect, and they don't turn up on the day of the inauguration, what would happen? Sam,
the law is not removed from common sense. Neither our courts or judges immune to reason. If there's a particular exceptional circumstance emerging that makes it difficult to comply with a constitutional timeline, an interpretation will be made in the circumstances, and that timeline will be deemed to have been extended. But in this particular case, the law doesn't say that once you've been gazetted and appointed, that you must present yourself to be sworn in within 24 hours. No, the law doesn't say that. Swearing in is at the convenience of the Chief Justice, the Chief Justice and the President to check the diaries and say we can do the swearing in at this point. I am not faulting. I'm not faulting the swearing in of those judges. I'm just saying that because they presented themselves to be sworn in, pursuant to the appointment, which was lawful, the President has now scored a political and moral dividend. But let me now deal with the question of the failure to appoint the remaining judges. I think it's indefensible, yeah? It's indefensible to prefer an argument. It's indefensible and unacceptable to prefer an argument that seems to excuse the President from performing his constitutionally ordained mandate. He has a duty. You know, these judges can't be appointed by a court order. And I've seen some conversations about going back to court. There is a petition, I think we discussed it off air yesterday. There is a petition that now seeks to compel the judiciary to have these judges to be deemed as appointed. We will never get there, Sam. The Constitution is deliberate that the President is the head of state, and he must perform certain ceremonial functions. The appointment of judges, he needs to know. He has no active role in terms of making it's a merely facilitative role. So when
he refers to reports of state organs, where do those reports lie?
And you posed a very important question. Maybe there is time now to reflect. Do we need to amend the Judicial Service Act so that to deal with rogue commissioners that can ignore serious intel on the integrity of some of these nominees? Because as it is now, Sam, the Judicial Service Act and the Constitution presupposes that the entire JSC will be acting in the best interest of Kenyans and in defense and furtherance of the Constitution. We do not anticipate, and the law doesn't anticipate that. Under the presumption of regularity, the law presumes that the Judicial Service Act and the Judicial Service Commission, the commissioners, in their conducting the interviews, they will not ignore anything that can make the candidature of someone untenable. But if they have done so presently, because that act hasn't been amended, the way forward is not to decline to make the appointment. The way forward would be make the appointment in compliance with the law, refer that intel as a complaint to the JSC. These people, the 6 nominees, are actually serving judicial officers. That intel, Sam, itself can lead to their removal, whether they have been promoted or not.
Okay.
Justice Odunga is on the bench. Mchelule is on the bench. Korir is on the bench. Joel Ngugi is on the bench right now. If there is a reason that can lawfully make the President have a moral burden, how am I going to appoint someone with all this dubious integrity? That reason can still lead to their removal as it is now. So I'm pleading with the President to have the courage and conviction to do the right thing. The right thing to do now is not to explain away his decision why he has not made the appointment, but to appoint them and then initiate the process for removal.
Okay.
Otherwise, Parliament, Mheshimiwa is here, she can comment on it. Parliament can then decide, can we then amend the Judicial Service Act? But I would not go that way. Remember, Sam, and we said this, in 2015, 2016, Parliament passed the Statute Laws Miscellaneous Amendment Act of 2015 to make it easier for the President to manipulate who becomes the Chief Justice. You see, now, these are hangovers.
But it didn't pass.
These are hangovers of cherry picking. Parliament they made the President so comfortable that insofar as appointment of the Chief Justice is concerned, we can give you some leeway. It took judicial intervention to stop that. But you can see now, the President is struggling to respect court orders, to respect the Constitution. He's saying, listen, I have information that can lead to removal of these judges. You get?
Sure.
I think that's what we need to reflect on.
As you respond, because a lot has been said here, but on the promise of Chief Justice Martha Koome, that time a candidate and now barely 2 weeks you see the appointment, and a statement saying that she had no role in that. What is her role in ensuring the completion of this process that has been stalled for 2 years?
Okay, let's put a correction there. I don't think Martha Koome, Chief Justice, said that she has no role. What she said is that Judicial Service Commission is functus official. What that means is that they've played their role, and after they give the names to the president, they cannot revisit the issue according to the law. Remember here, I want us to continue speaking to the rule of law. What is the law? The law is very clear. The judges that have been appointed, please do not say that they should not have taken the oath of office. They rightfully took the oath of office. And I don't think that the Chief Justice Koome was in a position to say, oh no, we are going to be activists and we are going to riot and refuse to go and take the oath of office. Because, let me tell you, Kenyans are suffering. And my counsel here knows. You know that the Court of Appeal has not been hearing any cases except under Section 5 something. Yeah. The one of stay orders only.
Yeah, stay orders only.
There has been no cases going on. There are families who are suffering. There are families who have gone bankrupt because they cannot deal with their properties. There is succession matters. There are people who have actually completely lost their lives because their cases are stuck because there were no cases being had at the Supreme Court. So even if I was a Chief Justice, for the sake of the people of Kenya, it was the right thing for the 34 judges to go and take the oath of office, go rescue the Supreme Court. You know, have you had a court case in the Supreme Court at the Court of Appeal at the moment?
Outstanding matters at the Court of Appeal, which have not, and dates were taken last year.
Yes.
The court has not.
Yes. By the way, people, I want people to understand the suffering that the Kenyan people have gone through. And even as I speak now passionately about this case, and even to be in this TV show, because I know how many people in Uasin Gishu County call me and tell me, my God, our cases are stuck. And I kept telling them, there is nothing you can do about it. There are no judges in the Supreme Court, in the Court of Appeal. I'm grateful that those 34 judges have now been sworn in. At least some can go to the Court of Appeal. At least some cases can begin to move. So that is not the fault of the Chief Justice, not the fault of the judges. I think what we are talking about here is Article 166. The person who has defied Article 166 is the head of state. It is not his job to cherry pick who goes to who becomes a judge or not a judge. And this conversation has not been held now. It was held at the appointment of Willie Mutunga. You must remember that very clearly. When President Kibaki attempted to say that you cannot give me one name, you cannot give me Willie Mutunga as the nominee for Chief Justice, you must give me another name. And he attempted to appoint Visram. You remember that? Yes. And that is when it was ruled and agreed that it is not the role of the president to be given 3 names. Whatever names he's given by the Judicial Service Commission, that is the name that he will appoint. It was clearly defined that the president's role is ceremonial, unfortunately. Just the way when they bring the BBI bill to Parliament, Parliament is a conveyor belt. The president in the appointments under JSC is a conveyor belt. And that is exactly how our lawmakers and the people of Kenya, when they were fighting for the 2010 Constitution, decided that is what should be done. So please, I do not want this taken against the judges who took the oath of office. They have saved Kenya, and it's going to help. The Chief Justice Martha Koome has nothing to do with it. There are 6 judges who have not been appointed. That is on the doorstep of the head of state. The head of state has defied not only a court order, he has defied the Constitution. The law is very clear.
Honorable Boss, let me cut you short, because earlier on you said that the Chief Justice didn't say that she had no role, but I would just want to read an excerpt of the statement she sent to
No, I think you read the statement correctly, but you misunderstood the meaning. Normally, once a court has made a ruling or a certain quasi-judicial body has made a decision, they become what we call functus official, which means they no longer have a role, which means that the JSC has given the names to the president. There is nothing in law that allows the JSC to revisit the list again.
Okay.
The president cannot return the list
Let me
to
read-
the JSC.
Let me
What
read the excerpt so that I can raise the question. She says that I wish to state that I had no part to play in this constitutional process, which was undertaken almost 2 years ago. Upon forwarding the names to the president, the chief justice and the JSC became Fanta's official or ceased to have any role. But the question I'm asking, because she's been in office, it was actually supposed to be her 13th day in office, and the president goes ahead to gazette those names. So one wonders, why did it take so long during the term of Chief Justice David Maraga, retired in January, and for a whole 4 months, no appointment. But when she's coming on board, she had promised us about negotiations. So did she negotiate to have the appointment? And if at all she did she know that 6 judges are going to miss out?
Okay, I do not speak to facts that are not within my knowledge. Those facts are not within my knowledge. But what I know is that the 6 judges that are remaining, if the president has any issues, and we have said this even before Martha Koome came into office as Chief Justice, if the president thinks that these judges have any issues, there is a legal route to deal with it. The legal route to deal with it is to present a petition to the Judicial Service Commission, even without them going to the Court of Appeal or any other court, and say that they have the following problems with them. The Judicial Service Commission shall consider it. And if the Judicial Service Commission finds that there is a prima facie case against the judges, they will then recommend the setting up of a tribunal to the president, and the president shall set up a tribunal. So, Article 50 of our Constitution and Article 47 of our Constitution talks about fair administrative action. It also talks about right to fair hearing, which means these judges have a right to fair hearing.
Okay.
They have a right to fair administrative action. The president must present those petitions. And it is not the first time that a petition has been presented to JSC by the executive. Remember that the DPP, Haji, presented a petition against Deputy Chief Justice Mwilu to the Judicial Service Commission. So there is precedent for that. So if the president has thought in the last 2 years that he has a case against these judges, let him present that to before the Judicial Service Commission. Do it the right way. It doesn't mean that if he thinks there is a problem, because the Constitution does not give the president the power to decide, I have a bad feeling about this judge. No, it's not about his feelings. It's about what the law says. If he has, and we agree, if he has a problem with those judges, please present a petition. And I'm sure the complaints he has against the judges were presented by somebody under an affidavit or so, and before the NIS. And that person can be told, please present your petition to the Judicial Service Commission and have those people removed. But the president, and please, these Kenyans must know this. If we allow the president to break Article 166, the next thing he's going to do, he's going to go under to Article 142 and extend his term as president. So we cannot allow him. Everybody must follow the Constitution.
Honorable Boss, I think what we do, just a moment.
Beatrice here swore to uphold the Constitution. I swore to uphold the Constitution. All of us swore to uphold the Constitution.
We need a bit of
Counsel here swore to uphold the Constitution when he was admitted as an advocate of the High Court of Kenya.
Let us not talk to matters that have not happened.
Yeah.
When they happen, we shall talk about them. But let us not have
and also
what he may call ulterior motive against the president. But I want you to have the final word on this, and especially now moving forward, there's that proposition that those dissatisfied with the picking of the 6 judges may present a petition. Is it a worthwhile proposal?
I think for me, Sam, first of all, one thing I have realized is that if we have a lot of anger to the president as a person, it becomes a bit very emotional.
I have anger with people disobeying the rule of law, not the president.
Allow her to finish.
Let's correct that.
No, I'm not correcting.
Allow her to finish.
I'm just saying, and I'm repeating, it is time we need, if we want to help our country, we need to remove these emotions. I always say, I like just being very objective on something. Now, for the last 2 years, we have had this matter. And I think Senior said here very well, if there's intel, And I think what the president has done, by the way, maybe he realized I need to also be human and protect this, because I know if I throw it also into them, and I've said it, if you throw it into the midst of the Kenyans, they will just forget immediately that they were supporting 6 and start another journey that you'll wonder what just happened.
Okay.
And I think that is one thing you have to protect, and you have to protect families, and therefore there are issues, fine. As Mheshimiwa is saying, you put a petition. And I'm thinking, first, we need to appreciate courts will proceed with the 32. We know we are going to finalize the 6, but I think it is important to understand they are men of stature in this country, integrity. They've worked in this country, and I keep on saying that because I know we destroy. We are a country that loves destroying people in their career. Fine. There was intel. Maybe it's, we might be thinking it's intel just from Kenya. Maybe it's intel also from outside. We don't know. And it is something maybe even the president has discussed with the CJ or maybe former CJ, and they felt, oh no, we will just ignore. And the other question will be, if you are the president of the Republic of Kenya and you receive intel of senior or my intel, do you want to tell me you'll just throw your country into because the law has said? I thought you also swore the Constitution that you will protect us. And therefore, we are arguing something we don't know.
Constitution.
We are arguing in something that we don't know why it happened.
You may make us to bring out the oath that the president took, but first...
No, the oath is you protect.
No, I'm saying it's because...
The Constitution, not Beatrice Elachi.
No, he has to protect me as my president.
Elachi and Honorable Boss, I want us to make progress and talk about what's happening at the Court of Appeal. And it was decided that the court hearing would begin at the end of this month. I just want to take a look at those timelines have been in as far as how it affects the Building Bridges Initiative process. And on the 13th of May 2021, you recall that there was that High Court judgment of a 5-judge bench led by one Justice Joel Ngugi. Then there was a 14-day period for people to file their appeals, and that period appears to have elapsed on the 28th of May. And then after that, what happened is that there was a case management conference held on the 2nd of June. That was on Wednesday last week. And beyond that now, what means is that parties will get time to file their submissions between that 2nd of June until the 28th of June. And then on the 29th of June, the case hearing proper begins and goes on for 4 days, where parties will have time to make their case, to reply, and then the judges will retire to go and consider all the evidence adduced before them and submitted before them, whether in oral or writing. And then we are told they may take at least 1 month to make a determination, and that may easily take us to probably early August or somewhere in the month of August at the earliest. Then if there's an appeal filed at the Supreme Court, then you repeat the process. So another 2 to 3 months taken, and that may delay the process of Building Bridges Initiative. Honorable Elachi, looking at all these timelines and all the desires that that were to have a referendum to make a choice by the Kenyans, and you're now starting the clock towards the 2022 election. How is that affecting that journey?
Well, first of all, we'll appreciate that I would want to leave it to the courts, because the courts can come in and finalize and give you a very short period to do what you would have to do. The same way we are waiting even the judgments that are coming for Nairobi. We don't know what the courts will say. They can decide to throw us into an election that we had refused and tell you where they left the timelines is where you start, and in those 21 days, we need to see something. So within the courts, you remember even when we were given our elections to be in March by Justice Lenoela, I mean, we have to appreciate that the courts will know how they will sort it out. For me, what we need to focus on is how do we ensure that IEBC, because I think that is the first institution we are supposed to now ensure it is complete. The commissioners, we have full commissioners who are supposed to be now working. It is for them now to prepare and they are supposed to be more ahead of even the courts, that you ensure everything you put, for example, you are supposed to start already preparing to know you're going for an election in 2022. And so for me, that process is very critical. A process that has to get finalized, that is in Parliament, with the panelists, shortlist the commissioners at least. Let us first have the institution that is supposed to come and take over all this, be fully constituted, and it's able to look at it. In terms of the timelines of how the proposers would wish, I know their wish would be we finish it very fast, we go into a referendum. But then we will have to look at what the courts will tell us and appreciate that now that you've gone to court, you will have to follow the timelines of the court. Now, if we find ourselves in a place where you feel that this is wrong, that now we are moving to an election, then we will ask ourselves, do we take it to be part of the election, or what do we do? I think that it has to be clear for our country, because this is where, and I want to appreciate that in 2005, when we were doing the referendum, when the government lost, Kibaki moved on and took the country to the next level. But what we are saying, we don't want to go to that next level the same way we were. We must, even the politicians in Parliament, should be thinking, how best is it to see Kenya moving into the elections of 2022 without taking us into any conflict?
Now that you mentioned the referendum of 2005, he may have been a very young person. I'm not saying a lot.
Goodness.
He was there.
But
that is so charitable, but fine.
When that happened, you recall that he fired his entire cabinet, reconstituted it.
Yeah.
And then the next 2 years were hostile and led us to 2007, 2008.
Exactly.
Chaos.
So
And
there are
that's why I'm
lessons we
asking-
have learned. And that's why I'm saying,
That's why I'm asking, is it tenable to have a referendum, if at all the courts agree with the BBI proponents, is it tenable to have a referendum before the August 2022 election?
yes, it is. It depends on what the courts will say. You know, that's why I've said, if the courts tell you, we have given you 21 days to finalize this stuff, so that you will have to follow the rule of law.
Okay.
Yeah.
And I want to bring you in here, but before I do so, one of the sentiments that were leveled by the President of the Court of Appeal on Wednesday last week, that is Daniel Musinga, is that there are pretty few other courts, and at that time there were just 13, and these were the judges. Daniel Musinga as the President, Mohamed Al-Sami, but also a member of the Judicial Service Commission, Kathrima Mtoinoti, also Director at the Judicial Training Institute. The other judges were, or are, Hannah Okwengu, Roslyn Nambuye, Wanjiru Karanja. There are three others that you will see there. That is Milton Makhanda, Patrick Kiage, Gatembo Cairo, and then there is Agnes Murgo, Fatuma Sichale, and Jamila Mohammed. And then the 13th judge at that time was Sankale Olekantai. But now, with the swearing in of 34 new judges, they got 7 new judges that may help matters at the Court of Appeal. And these are Francis Toyot, Helen Omondi, Pauline Nyamoya, Musaga Bogoli, I hope I pronounced that right. Then the other 3, you have Dr. Kibaya Imana Laibuta, and I have to say, might be the first judge with that sort of visual disability, Jesse Lesit, and Mumbi
A brilliant man.
Ngugi. Indeed. And Advocate Ogola, so Kenyans are asking, these 7 new judges, are they candidates for the 7-judge bench? And how was the timing read?
No, the short answer is yes. So nothing stops. Most of them are serving judges, and they have experience in terms of resolution of this. They don't need further training or orientation to be able to sit in this bench. So they can, yes. So that is the short answer. Yes.
But what I'm asking is, because there are those that said in the political circles that the appointment of the new 7 judges alongside the other to make the list of 34
Yes.
may be misconstrued to aid matters at the Court of Appeal. Is that even anywhere placed within
Maybe
fairness?
yes, no, maybe yes, maybe no, but does it matter? Because they're already judges and they'll be deployed wherever place they want to go, if they're going to be asked to sit into the BBI appeal, that's fine, because now they are judges, they have been sworn in, and they are working. So I don't think we should have the liberty to pontificate so much about the reasons why and the timing about their swearing in. They should have been sworn in a long time ago. If their swearing in matches an appeal, it could be a pleasant coincidence. But I mean, does it really matter? It doesn't. But I think the more urgent question of constitutional and political relevance is this. Honorable Elachi already spoke to it. Is it possible, in terms of practical reality, to have a referendum before the next general election? The answer is more likely no, because there are legal and political challenges. There are legal and practical challenges, that is. Let's deal with the practical challenges first. The reality is the Court of Appeal needs at least 3 months to determine this appeal. 1 month has already been spent. The Supreme Court, because the matter will certainly terminate at the Supreme Court, the Supreme Court will need an identical amount of time, at least 3 months. That takes us to November, December. Even if the Supreme Court clears the way for the referendum, IBC then has at least 90 days to be able to prepare and conduct the referendum. That takes us to May, April, May. Now, the practical sense question is this. Is it, and you talked about the burden of choice, is it necessary to run a referendum in May, April, May, when you have a major election in August? I think the practical reality will mitigate against holding a referendum. But legally, it's very unlikely that the Court of Appeal will overturn all the findings by the High Court. The Court of Appeal needs to overturn all the findings by the High Court if it is to clear the way for the referendum. If it preserves one finding by the High Court touching on the procedure or the process or the substance, then the entire bill still collapses. Be it as it may, if the Court of Appeal overturns all the findings by the High Court and the matter goes to the Supreme Court, you still need the Supreme Court to uphold the finding of the Court of Appeal, overturning everything that the High Court said. I think legally I can tell you there are at least 10 grounds that will succeed, that will not, the Court of Appeal will not overturn from the finding of the High Court.
Okay.
And those findings may still be upheld by the Supreme Court. So legally speaking, I think it's safe to say that we need to make peace with the fact that BBI as we know it today is dead, which then now raises the other question, the alternative question. All this conversation was about the basic structure doctrine, but there's a sister doctrine there, the doctrine of colored legislation. Because what Parliament will begin to, and I hope Mheshimiwa can speak to it, what Parliament will begin to do now is to reflect on the reality before them. And the President will also reflect on the reality that we may not have a referendum because of practical, political, and legal challenges. But how can BBI process re-emerge in Parliament, and so that the President has a decent chance to do what he wanted to do within a parliamentary-driven process? Can he do so? I think that, yes, the short answer is Parliament can revive the BBI process, but what Parliament needs to be careful not to do is to color that legislation, because the doctrine of colored legislation is about legislation with so many impurities that it cannot stand the test of constitutional scrutiny. Parliament now needs to know what it can and what it can't do if it's going to support the transformative agenda the President was pushing through the BBI framework. That is where the real battle really is. Not at the Court of Appeal, not at the Supreme Court, because the hurdles at the Court of Appeal and the Supreme Court are almost insurmountable. Parliament has 13 months. What can they do to advance? And whatever they do, they must be careful to ensure that it does not undermine the gravamen of the judgment from the High Court. And
you're talking about this at a time that even the parliamentarians themselves will need to take leave, quote unquote, to go and prepare for the election. But you've been the chief registrar of the judiciary at some point. What does it take for a newly sworn in judge to start sittings? Do they go through a bit of orientation? How long does it take for them to be ready to sit?
Okay, first of all, when a judge needs to take up office, the first thing they do is to first finish up all the cases that they had at the lower court. That is the tidy thing to do. And that is why once they are named, they don't take up new cases. they clear the old cases that they have. Because remember, there are some people who have had hearings before those judges for the last 10 years. And then, if you say that judge moves to the Court of Appeal and does not finish their case, it may be, if one person opposes it, it means the case has to be had de novo again, which means it has to go back and start afresh. Some witnesses have died, some evidence has been lost. So it is great injustice to the people who are before the court. So the tidy thing is to let those judges finish the cases.
Even now when they've been appointed judges of the Court of Appeal.
Yes, they owe the people of Kenya a duty to finish those cases.
Yes.
If they decide just to pack up and go, imagine how many Kenyans are going to suffer to have their cases restarted. I have seen cases restarted after 10 years, and they've lost half the witnesses who are no longer alive.
Are they therefore available for this urgent matter at the Court of Appeal?
Yes. I think those are administrative measures. Sometimes what happens is they go to the Court of Appeal, they are sworn in as Court of Appeal judges, and they can start hearing Court of Appeal matters. But they can continue to hear the cases that are pending before them at the lower court. That is possible. But currently the judges are stretched to the limit. I'm telling you, if anybody spoke to the judges and speak to the lawyers who appear before them, they will tell you the judges don't know what to do. They have so much on their plate.
Help me here, Honorable Boss, because when you said that for the sake of example, Justice Mubi Ngugi has matters before her, the High Court. She's been sworn in as judge of the Court of Appeal. Now she takes a bit of time to clear what is on her table at the High Court. These are matters that may find her at the Court of Appeal. So how
it's allowed.
do you deal with that?
It's allowed actually in practice. What happens is she'll be a Court of Appeal judge, but she can continue to go back and complete the cases that she had at the High Court. That is allowed. But then, even in deciding those cases, because there are so many, she will look at the cases that maybe 2 witnesses are left, or she's waiting to write a judgment, and so on. But the ones that have not started, she may shelve those for her successors to be able to take over. But on the ones that have gone way too far, for the sake of justice, that can happen. But let me speak to a point here about saying that BBI will happen.
Can I play a clip before you
Let's talk about the timelines. Remember, the timelines for the...
Let me
just... This is very important because I think...
It is actually relevant to that. Let's just listen to what the President had to say in Kisumu during Madaraka Day celebrations as he reflected on the judgment against the BBI.
Then there are questions the judiciary would have asked. If BBI were to be stopped, who carries the burden of choice? On whose shoulders will ethnic majoritarianism rest? And who will carry the burden of losing 30% of our national budget every 5 years due to the toxic politics that BBI sought to resolve? The judiciary would have asked itself another question. Can Kenya truly be a democracy if the people are denied the opportunity to express their sovereign and supreme choice at the ballot box on the basis of elevating technicalities over the overriding objectives of the law? Our Constitution, fellow Kenyans, is not a yoke around our necks, but rather it should be a mighty sword that can break the chains that limit all of us as citizens.
So, as we wait for the process to go through the Court of Appeal and possibly at the Supreme Court, there are certain things that were proposed in that BBI process. You may not agree with some, but there are some that will help this country. What, in your view, would be the best approach to ensure that you don't lose everything because of the judgment?
Yes, thank you, Simon. I hope you're going to give me enough time to speak now, because I seem to be getting very little time. I think what the President has raised there is very persuasive. But those are facts that he should raise in the court. He should either tell his lawyer or his legal advisor, who's the Attorney General, to raise those issues. And remember, you don't raise them just by speaking words. You don't say the burden of choice. When you talk about the burden of choice, it has to be supported by a law. It has to be supported by scholarly works on legal frameworks such as this. It has to be supported by precedent. It has to be supported by decisions that have been made around the Commonwealth and in Kenya. So it is not just about saying it. So he has persuasive thoughts. I ask him to get a good lawyer and get the Attorney General to make those persuasions that he made at Madaraka Day before the court. Because the court is not going to listen to what he said at Madaraka Day speech. Well, I'm actually very saddened, and I feel very burdened as a Kenyan that I continue to come on this TV show to talk about the same thing all the time. It's about time that we stop discussing this issue. Let it leave it to the courts and let it be argued before the court. It is not our place. When we talk about that BBI is a good thing for Kenya, that's fine. We can talk about it here and say it's a good thing for Kenya. My colleague here, Mheshimiwa Lachi, says that it's a good thing. It is. If she believes it's a good thing, let the lawyers go and argue it before the court and let that be put there. When we talk about the timelines for when the BBI should be held, remember, those are not timelines that I decide or you decide. The timelines are legal timelines. They are decided by the law. The law says public participation is 90 days. Voter registration, voter education has so many days. I worked in the Electoral Commission. One of the things that we did is we prepared the timelines according to the law on a Gantt chart. And I still remember when we had the 2010 Constitution referendum, God rest his soul, Mutula Kilonzo Sr. was the Minister of Justice. And I remember sending him the Gantt chart, and I told him, you know what, Waziri? It is impossible to have the referendum on the days that you've said. And he said to me, why? And I gave him the Gantt chart. And we color-coded it, and we put the dates, and I said, this takes 90 days, this takes 120 days, this takes this, according to the law. He then said to me, what is making you do it at 120 days? I said, we need resources. He said, you will get the resources. He said, why is this happening this way? I said, because of this. And that is the negotiation you have to have. It's a negotiation also with the National Treasury and the government in order to decide how you're going to decide. And then you must also, a very important point that was raised by counsel here, there were 23 decisions in that judgment that was passed. Even if 20 of them were approved, I know there is at least 4 that will never be broken. So what will happen is we will be back to the same place that we were. And I think right now, what is happening is that people around the president and the legal advisor around the president are in denial. The president should start listening to other people to tell him, actually, if I was advising the president, and I'm giving this free of charge, drop it as a popular initiative. Bring it to parliament. After all, he has ODM, the opposition is on his side, and he has a group of his Kieleweke team. He actually has the numbers. So why doesn't he just bring it to parliament? That is the easiest way. It is the way to do it. So let us stop lying to the president. Let's advise the president correctly and tell him, if you really want this. And also, 75% of what is in the BBI amendment bill can be implemented through legislative and policy decisions. It does not require for it to go to a referendum. The things that need to go to a referendum are less than 4
all right, Honorable
clauses.
Honorable
and so why don't we focus on that? He just has the wrong advice.
You say 75%, I don't know how you quantified that, but let's see what Kenyans
if
are
you
saying
give me
on
a
Twitter.
whole show of 1 hour, I will tell you.
No, you said that you don't want to discuss that any further. So let's look at the feedback that has been sent to us. This is a mother. You're saying that if the law is that rigid, why not talk of President appointing 41 judges as per memorandum and not 40, I don't know what that means, one of them posthumously? Why is leeway in the Constitution for the change? Okay, I think he's talking about he should have appointed 41 and not 40 because of the deceased. Julius Otieno, there is nothing wrong or illegal in appointing the 34 judges, but there's something wrong in not appointing the 6 judges.
True.
Gola, a wise counsel, knows the difference between morality and law. What is immoral is not necessarily illegal, nor law broken. Well.
True.
Okello, you say, Okol, legless, you say, lesson. No president will allow his representatives in JSC to sleep on the job. They embarrass the president, as is the case with the 6 judges. Then Fantas Mutiga, the judges left out should be appointed as early as possible. Executive is overstepping their mandate. Justice is very necessary for metamorphosis of democracy. Jacob Abere, you said that as a nation, we can't afford to lose gains. We have made appointments of judges, but JSC deemed gone through. This British tradition of taking them to State House for ceremonial purpose kills independence of 3 arms of government.
Good point.
Well, then Engineer Lazaro, you said that how do you expect the president to participate in promoting the same judges? He contested their verdict in court and the case hasn't been concluded. JSC